Welcome to 80/20 Estate Planning, the show that explains smart ways to get the most from your estate and planning team, with your host, Hal Gibbons. In this 13-week series, Mr. Gibbons and his guests will be discussing a multitude of critical and helpful topics, including his own 80/20 process. Feel free to call in with your questions, 621-WALE or 1-877-621-WALE. Now, 80/20 Estate Planning with Hal Gibbons.
Welcome to 80/20 Estate Planning. This is Al Gibbons, your host, and I have two wonderful guests with me today. First, it's my pleasure to welcome Hal Hershgordon to the show. Hal is a private client advisor based in Philadelphia and is with the international advisory and consulting firm of Deloitte & Touche. Hal is a graduate of Temple University and its Beasley School of Law. He is a member of the Pennsylvania and New Jersey bars, is a CPA, a personal financial specialist as accredited by the American Institute of CPAs. Hal has enjoyed serving a national client base and has been privileged to serve as a trusted financial advisor to prominent, closely held business owners and high net worth individuals and their families. Hal provides independent, personal financial counseling advice on a fee-only basis in the areas of investment management, estate planning, risk management, and philanthropy. It is my pleasure to welcome Hal Hershgordon to 80/20 Estate Planning. Welcome, Hal.
Good afternoon, Al, and thank you for that warm introduction. I'm delighted to be a part of your show.
Nice to have you with us. Also, I have on our program a very prominent attorney from New Jersey, Frank Demmerly. Frank R. Demmerly, Jr. is chairman of the Estate and Trust Department of the very well-known New Jersey law firm of Archer and Greiner. Frank has more than 20 years of experience in estate planning for closely held and family businesses, estate administration, and estate, gift, and transfer taxation. He also represents numerous business clients in the areas of general business representation, and together with the various departments of his firm, provides corporate partnership, merger, acquisition, sale, contract, labor, litigation, real estate, environmental, tax, financing, and other legal services for clients. Frank has his AB from Princeton University and his JD from Georgetown Law Center. Frank has lectured and written extensively and is a member of numerous professional organizations. My friend and well-known attorney from New Jersey, Frank Demmerly. Welcome, Frank.
Well, thank you very much for that introduction, Al.
Okay. Well, it's nice to have both of you with us. We are in the 13th part of a 13-part series, and appropriately as we talk about estate planning, today we want to talk about post-mortem estate planning. Is there such a thing? And what we're talking about is after death, are there still opportunities? So what we find, Frank and Hal, is when we talk about post-mortem estate planning, when someone has passed away, either that person has a will designed to allow post-mortem estate planning and some flexibility, or without having updated his or her will with the most effective estate planning techniques and so forth. In either case, there are opportunities to do some post-mortem estate planning. Hal, why do people do post-mortem estate planning?
Well, I think, Al, the number one reason that we do estate planning is to try to effectuate the decedent's wishes, really to carry out, as a form of respect, what the individual who passed away, what they wanted to have done. And I think that's the cornerstone of why you do post-mortem estate planning. And some of the opportunities that, you, I, and Frank will discuss are merely tools and techniques to kind of do that what I believe is the laudable goal.
So I guess what you're saying, Hal, is at death, there are many times when perhaps the perfect estate plan is not in place, and we still have some opportunities maybe to do the things or some things that are necessary to get it in place. Is that what you're saying?
Absolutely, Al. Oftentimes that is the case where the decedent failed to take advantage of all the opportunities that he or she could,
okay.
And we are able to help remedy and improve the situation.
Okay, great.
I think there are a couple other things, Al, to keep in mind.
Good.
It's not uncommon for our clients to have done their wills 3, 4, 5, 6, 7, 10 years ago, and although we encourage them to come back and review their planning with us every few years, it doesn't always happen. As time goes by, asset ownership changes, intentions change, the tax law changes, and occasionally someone unexpectedly passes away, and the planning that was done very well at the time doesn't quite accomplish what everybody would like to accomplish now.
So, Frank, this is real world stuff. I mean, it's nice to say that all of our clients have ideal estate plans, but the fact of the matter is they change, or the rules change, or their situations change enough that we do need to look at this area. There are some huge opportunities.
Oh, I think that's true, and then even in the best planned estates, there are still multiple options to be considered after death that may have been contemplated in the original plan.
Well, now that I think about it, we've always said in estate planning that, and this is sort of a fundamental in 80-20 estate planning. When we're sort of the premise is that it's very difficult for us to get the 100% plan today. It's virtually impossible to put together the perfect estate plan today because we would have to know things that today we don't know. They're unknowable. When we're going to die, what our relationships with our children are, what our assets are worth, what the market's doing, and so forth. So post-mortem estate planning, now that I think about it, is a cornerstone to 80-20 estate planning.
Absolutely, Al, I would agree. And Frank brings up some very excellent points that even in in the best planned estates, what you said, Al, the fair market value, if we look at the stock market, say 6 or 8 months ago as compared to where it is presently, and the precipitous decline, the mere fact of someone passing away 6 or 8 months ago with an excellent estate plan at the time would still provide us tremendous opportunities today when trying to effectuate that decedent's wishes.
Good point. Frank, who does the post-mortem estate planning? Obviously, it's not the person who's mortem at that stage. It isn't the person who's died. Who does it?
Well, I think the post-mortem estate planning is really accomplished at the layman level by two different people. One may be the person who's the executor or trustee of a will and a trust, and the other may be the actual beneficiaries of the estate. Both of them will have elections that they can make and decisions that they can make which will affect the tax consequences and who gets the property of the estate. Most of those people will be consulting with their financial consultants like yourself, Al, their accountants like Hal, and their attorneys to see what their options are so they can then move forward to get the right dispositive plan, as Hal has talked about, and to get the best tax consequences.
Okay. Hal, in your experience, how does one do post-mortem estate planning? Are there some, just in general, some basic techniques that might be used? And we can come back a little bit later in the show and talk about them in detail.
Sure. Yeah, to give you kind of an overview, Al, I would say, Frank, I absolutely agree that two classifications of people that might be able to affect estate post-mortem planning are executives and beneficiaries. And there's kind of two general ways I think about it, Al and Frank. Number one, it can be beneficiaries can use something called a disclaimer power, which is, it's an unconditional refusal to accept property. And that's a very effective tool, and it can be used in a lot of different ways, but as kind of an umbrella, Al, that would be what beneficiaries have and what their trusted advisors in helping them understand their situation.
Well, Hal, I am interested in hearing more about how I can refuse to take assets.
And even why you might do so.
Okay, so we will talk about that later in the show, and I'm sure our listeners are going to be interested in that.
Great. And the second major category you asked to paint was elections, a term that Frank used. And there's a variety of elections that principally the executor acting as the fiduciary, or actually the one on behalf of the decedent who no longer can speak for him or herself. There's a variety of elections that can be made to get to the dispositive scheme and get the property in the hands of what I like to term as the intended beneficiaries, and keep as much property away from what I call the unintended beneficiaries.
Okay. What about, Frank, what about taxes in post-mortem estate planning? Is that an important issue?
Well, taxes are always an important issue, and quite often the issue that is uppermost in the minds of the family that's surviving, because taxes, as you know, estate taxes can go to the rate of 55%. So quite often, post-mortem estate planning will be looking at how to avoid estate taxes, how to reduce estate taxes, as you look at assets passing over the entire family.
So the decision may involve more than just looking at it at that moment in history, that moment in time. You're also making planning decisions, perhaps for the next generation or future generations.
That's exactly right. I think once we get into disclaimers and we get into some of the elections that can be made, we'll see there are opportunities to pass property not only to the surviving spouse or perhaps the children, but also perhaps to the grandchildren. And one of the great opportunities of disclaimers is you can leave the door open. You can take a wait-and-see approach if you set the estate up properly so that the survivors can decide how they want the property to ultimately pass.
Okay.
That's an excellent point, Frank, and it's at the time of death, which can take into those circumstances. One point I would add, Al, is it's also in saving taxes. Frank mentioned estate taxes, but one would often want to look at the overall tax structure, and that would include income taxes both to the estate and to the beneficiaries, as well as estate taxes.
Well, now, this may sound like a silly question, but when should we do post-mortem estate planning?
I think the best time, Al, would be before someone passes, but then it would be immediate pre-mortem. But to answer your question without the humor, I would say as soon as possible after death is when it would maximize the flexibility. Consulted advisors, as soon as the survivors are able to, from an emotional standpoint, maximizes the flexibility, because in estate administration and the process, Al, as you and Frank are well aware, there are deadlines. In other words, after 6 months in time, certain elections that we alluded to earlier, and we'll discuss in more detail, become no longer able to be elected. 9 months after date of death, other things have to happen. So it's a very time-sensitive process, and that has to be balanced against the emotional and psychological aspects of the survivors.
Let me jump in a minute, Al, and say I agree that Hal is right, but also in the pre-mortem estate planning, you may be thinking about the possibility of post-mortem estate planning, and therefore when you're doing the pre-mortem planning, you may want to be setting up some of your documents, some of your beneficiary designations, so that there will be an opportunity to do some of this other planning.
Well, I do want to come back in a minute or two and talk about this immediate pre-mortem planning, because I think that is a very important point. We ought to spend a few minutes on it. But also I'd like to reconfirm the points that both of you are making, that I find the more experience I get that it is imperative that people not do just transactional estate planning. In other words, they go to an attorney or they bring their accountant in or whatever, they have the wills drawn up, and then they put it in a drawer and don't do anything anymore, and then death occurs and the family's just sort of left doing this, whatever they do, and they don't take advantage of post-mortem estate planning. I think it's important that our listeners understand that they need to have an ongoing relationship with their advisors, so that after death it makes perfect sense to call in these advisors and say, what is the best course of action? Do we have options? And should we move forward together as a team and maximize our opportunities here, or minimize our losses, as the case may be? And I think that's an issue that many people overlook in planning, and I think post-mortem estate planning is not done nearly enough. Let's do this. Let's take a break, and after the break, when we come back, let's talk about this idea of pre-mortem estate planning first, and how we position ourselves for after death and how we do post-mortem estate planning. We'll be back right after the break.
80/20 Estate Planning will return after these short messages. Mortality. Who dwells on it? But when it comes to planning your estate, it's never too early to start. For smart ways to get the most from your estate and planning team, you need to hear Al Gibbons, creator of the heralded 80/20 Estate Plan. Implement 80% of the planning you need in 20% of the time it normally takes, from A to Z in 60 days. Contact AEG Financial Services today at 610-917-8940 or email them at algibbons@algibbons.com for more information about Al's expert services and related products. Al Gibbons of AEG Financial Services is a highly respected expert in the complicated and often confusing world of estate planning. Put his years of experience in dealing with real situations to work for you. Contact AEG Financial Services today. Call 610-917-8940. That's 610-917-8940 or email algibbons@algibbons.com.
You take vitamins to supplement your diet? Millions of people today blindly consume vitamins and supplement products without any knowledge of what they're taking. Do you know the difference between synthetic, fractionated, or whole food supplements? Standard Process does, and for 70 years they have produced the best all-natural whole food supplements available. Standard Process was founded by Dr. Royal Lee in the 1930s. Standard Process is producing their unique food supplement containing a complete dose of vitamins and minerals with their naturally occurring synergistic trace elements. All this from an organically grown whole food supplement. Find out for yourself. Call 1-800-848-5061. That's 1-800-848-5061. Call Standard Process today and feel the difference. Call 1-800-848-5061.
Hey you, sick of the same old talk shows? Are you searching for a show that only deals with men's issues? Keeping It Real is the show you've been waiting for. Hosted by former Mr. Rhode Island Greg Norman, Keeping It Real is doing just that. Keeping It Real. The show features real-life stories of personal transformations as well as sharing personal knowledge and wisdom. So tune in to Keeping It Real every Tuesday at 5 to 6 p.m. right here on WALE. It's the show for men. That's Keeping It Real with Greg Norman every Tuesday at 5 to 6 p.m. Be there.
In the last 2,000 years, no one has had more influence on the course of history than a man named Jesus. But it's shocking how few people know what Jesus really had to say. I'm Ronald Dart. Tune in for Born to Win every Sunday morning at 9:30 right here on AM 990 WALE. And we'll talk about what Jesus really said.
Talk to our expert host. In the Providence area, call 621-WALE. Outside the Providence area, call toll-free, 1-877-621-WALE.
And now back to 80/20 Estate Planning. Here's your host, estate planning expert, Hal Gibbons.
I would like to welcome back my guests, Hal Hershgordon of the International Advisory and Consulting firm of Deloitte & Touche. Hal is located in Philadelphia, and also Frank Demmerly, chairman of the Estate and Trust Department of the New Jersey law firm Archer and Greiner. Welcome back, gentlemen.
Thank you, Al.
I think we were able to set the stage for our discussion today in our first segment in talking about some of the issues in post-mortem estate planning. And one of the points that both of you hit on very eloquently was this issue of actually pre-mortem estate planning, or planning, I'm not sure we'd want to refer to it as deathbed planning, but when someone's sick and prior to death, some opportunities that we have in that regard. And I think, Frank, one of the things that you said is it gives us an opportunity to position ourselves for things that we might be able to do after death with some of the families that we work with. Could you explain a little bit more about that, or maybe give us an example?
Well, let me do talk about that. Quite often, we want to take what's called a wait-and-see approach. Let's wait and see what things look like after someone has passed away, and keep those options that we can keep open. Let me give you an example. We have a client who had a relatively large individual retirement account, about $1 million, and the client also had significant other assets. So the client's spouse was not sure at the time we did the planning whether, it was a she in this case, whether she needed all the individual retirement account for her benefit if her husband passed away. So what we did was we set up the individual retirement account so the primary beneficiary was the spouse. The contingent beneficiary was the children, and we had a third contingent beneficiary being the grandchildren. Now, when the husband participant passed away, we first went to the spouse and said, "You're the beneficiary of this account. You can take the entire account. It would be for your benefit." We then brought in the financial analyst and looked at whether she really needed the entire account, and she decided she did not. So rather than suspend that account in her estate, she disclaimed a portion of the account. In this case, she disclaimed about 60% of the account, so that now she was the beneficiary of $400, which she rolled over, and her children were then the beneficiary of $600. Well, there were 3 children, so they reached the beneficiary of $200, and one of the children said, I don't really need it, so I'm going to disclaim it and let it go to my children. So now the account has been spread among the spouse, the children, and the grandchildren. As everyone may know by now, there are new rules on distributions from individual retirement accounts. We can stretch those accounts if we do it right over beneficiaries' lifetime. So the portion that the children took, they'll be able to have a minimum distribution over their lifetime, and the portion that the grandchildren took, they can withdraw over their lifetime. So here we have a good opportunity to say to a spouse, who is usually the primary person we're worried about, do you want this or not? But if you don't, we could do some post-mortem planning, which will move some of these funds down to other members of the family.
Frank, you make several excellent points there. In doing this pre-mortem estate planning, it looks like one of the issues here is making sure that in this wait-and-see kind of situation that you're describing, that you have the beneficiary designations successively done correctly, so you have the opportunity to disclaim or move to the next generation or whatever. So that was one of the things that was afforded to you. Is that correct?
That's exactly right, Al. You want to be able to line up and make sure that you have primary, secondary, tertiary beneficiaries, so that there will be an ability for the beneficiaries to decide how to allocate this.
The other thing that you brought up was we were here dealing with IRAs or qualified plans, and it looks like under the new rules that one of the issues with these minimum required distributions is that there is actually a bigger need for post-mortem estate planning than there has been in the past. There are more opportunities. And certainly this is an asset we're going to be working with often in post-mortem estate planning.
That's absolutely correct. I think it would be a mistake for any beneficiary of an individual retirement account not to consult with one of their professional advisors as to the proper method of rolling it over, withdrawing it, or if they're willing not to take it all, disclaiming it, because the opportunity is just tremendous with the new regulations passed this year.
Well, you have said that very strongly, and I agree, and I think it's a very good comment, and I would go one step further, and it's to make sure those advisors are also involved in making sure those beneficiary designations are correct prior to death. Hal, I'd like to talk to you about pre-mortem estate planning, what some of your experiences have done.
Sure, Al, it's my pleasure, and I do think that Frank's example is excellent. And Frank, I would ask you the question, you probably made that wait and see, as you call it, or I think about that as, maximizing the flexibility for your clients. You probably made those decisions even before the new regulations had taken place, correct?
Well, as a matter of fact, we did, yes.
Yeah, so as Al, you indicated earlier in the show, it shows why when this is done best, it's done best in a relationship-oriented process with advisors as opposed to transactionally.
Yeah, and with real professionals.
Yeah,
this requires some expertise.
Yeah, I think Frank's story demonstrates that well. Some of the experience I had, And it is kind of heart-rending for me, Al, I would say. I counseled someone who was a woman in her mid-30s and unfortunately contracted cancer, and it became terminal. But we did have some time to really get her affairs in order, as people think about it. And some of the things we did, Al, were review her documents. Take a look at her will, a durable power of attorney, make sure that her durable power of attorney enabled what they're called attorney in fact, the people acting on her behalf, to make gifts and to take advantage of other opportunities if the point became where she was not able to do it on her own, yet still alive. So I think one of the things that's really
Well, that's
important,
a big issue. Excuse me for interrupting.
Sure.
But this idea of making gifts and getting things out of the estate, or making sure your durable power of attorney provides for making gifts, is really a huge issue, is it not?
Yeah, it's because it's a way, again, it's a way to effectuate what the person who's still alive, who ultimately passes away, is going to want to do. And there's certain types of gifting, as you and Frank are aware, that once someone passes away, they're no longer able to give the $10,000 annual exclusion gifts per person, for example.
Right.
Or or the tuition exclusion, or medical, pay medical expenses. So those are some of the gifts that once someone passes away, you'll lose the opportunity.
Okay. Well, this pre-mortem, obviously we could spend a show or two or three on this pre-mortem planning, but what I'd like to do is let's sort of close this section off. Let's take a break, and then after the break, let's spend the rest of the show on post-mortem estate planning and what it is and how we do it. So right back after this break.